Good afternoon, everyone. My name is Katherine Aquino-Melendez. I believe there's a few participants still joining, so I'll give them a few more minutes, and then we'll get started. For those that are already on, I want to thank you for joining. I will be doing this presentation in English the first half and in Spanish the second half. Buenas tardes a todo el mundo que está participando. Mi nombre es Katherine Aquino-Melendez. Soy abogada en la firma de Cuddy Law Firm y voy a hacer la presentación, la primera parte en español, en inglés y la segunda parte en español. Okay, so today we're going to be speaking about life planning for families with special needs. I'm actually an attorney at the Cuddy Law Firm that does a lot of the special needs planning with our clients and estate planning. So if you have any questions, feel free to ask. We'll leave the questions for the end, just before I transition into Spanish. And I think maybe you can even type your questions. Amanda may be able to confirm that or open that up for questions. So a few questions to ask yourself, right, is who's going to care for my child when I'm gone? Where's my child going to live? Oh yes, Amanda, I'm sorry to interrupt. Amanda just opened the chat, so feel free to type questions down there. Who's going to make specific decisions regarding medical attention or medical decisions for my child? Who's going to manage the care, educational decisions? Is there going to be enough money to support my son or daughter when I'm no longer around? So these are all very important questions that you may be asking yourself or you should be thinking about, especially in the current situation that we're living in, this global pandemic of COVID. I mean, it's opened up a lot of people's eyes to planning and the realization that you have to be ready for whatever may come your way. So what is life planning? Life planning is a thought out plan that involves everyone in your circle and recognizes your child's needs. It's not just a child with special needs. It can be, your typical child. Who's going to provide, the support, the medical attention, the educational representation for your child, whether a typical child or a child with disabilities, if you're no longer around. Developing this plan will allow families to provide the best quality of life possible and assist the child develop to their fullest potential with the necessary support. You may have a plan set up that the child's proposed guardian, right, if they're under 18 years of age, and you've appointed them as legal guardians in your will, they may already know what to take care of. But if not, again, these are things you want to think of. And even if you do have it, consider reassessing the plan. What does the life plan consider? It's the child's medical, behavioral, social, emotional, educational, and vocational needs. The family's assessment of the child's needs and their hopes for their future. Assessing financial commitment required to support this child, right? If your child's used to a specific lifestyle, is there going to be enough funds in your estate to help this child continue to live a certain lifestyle that they're used to? Or if the child requires specific financial support, maybe there's a day program that you send them to every single year, or a summer camp, right, that provides specific therapies or developmental support. Are there going to be enough finances available if you're no longer alive to continue the upkeep of these programs? Some other considerations are is your child capable of supporting themselves, or to what extent can they support themselves? Sometimes the need may be a lifelong need. You can't always rely on government benefits, right, and supports that are currently in existence because they may not be available in the long term, in 10, 15 years from today. What are the capabilities of the child, right? I slightly touched on this at the beginning. It's if they'll be able to work by them, in the future. Will they be able to sustain themselves? Do you see them having a family of their own? Maybe getting married and having some extra support from a spouse or children, and that you don't necessarily have to rely on your immediate family members or proposed guardian for that individual. Some actions you want to consider, right, is developing a life plan, putting together a team of professionals, especially if your child has special needs, that knows and understands the needs of this individual, and develop a life plan. Review your estate planning. This is so important, and I cannot emphasize this enough. Estate planning is essential for everyone and anyone. If you're over the age of 18, you should at least have advance directives in place. Now, an individual may not have the capability or the capacity to execute advance directives, in which case you may want to consider guardianships or at least a supported decision making. If you have your estate planning in place, make sure that you're reviewing it and revising it, right? Because maybe some individuals you've appointed as agents or, powers of attorney may no longer be alive. You may not have a relationship with them. You may have realized that, you appointed your best friend as the proposed guardian for your child when you developed a will and your child was a newborn, but maybe along the, life has happened and you've realized that your child has a better relationship with your cousin. So maybe you want to change the proposed guardian to your cousin, to your child, the cousin versus your best friend that you had assigned as a guardian. Get your own life in order, and this will help you get your child's life in order. You see, there's a question, what are advance directives? Advance directives are what we know as a power of attorney, healthcare proxy, a disposition of remains, a living will, and a HIPAA release form. These are documents that you execute at an attorney's office. And the two most important documents that I've mentioned from the advance directives group are the healthcare proxy and the power of attorney. Power of attorney, you appoint a power of attorney, an agent, to make decisions for you. Usually it's business decisions. They may be able to open bank accounts on your behalf, sign, a contract on your behalf. Basically, the financial responsibilities. A healthcare agent is a healthcare agent that can make health and life decisions for you. So again, these are very important documents, and those two are very important, especially right now. Life plan components includes a letter of intent, again, a well thought out estate plan, a team, right, to approach the planning. The family attorney, your financial planner, you have a family accountant. It's coming up with a plan for your current life and the future. Reviewing your planning on a regular basis. Again, maybe within every 10 years, you want to reassess your estate planning documentation to make sure everything's in order. Because what you don't want to happen is you develop an estate planning, you have children later down the line, you forget to revise your estate planning, that child or children that you had after the fact may not be included in that estate planning. Or you have specific people, appointed, and in 30 years, you've lost touch with these individuals, but they're the ones that are going to be then responsible for your life planning. and your estate planning at the end of your life. So again, it's so important to reassess these documents. Have a team meeting, right? A family meeting. Everybody has a responsibility. Everybody knows what your plans are. Everybody knows who the accountant is to contact, which attorney you're working with. Maybe memorialize it. Give it to the people that are closest and dearest to you to have in case something does happen to you. If you have an attorney, speak to that attorney, your accountant. Share all the contact information that you can with them, right? It's just very important to have other people aside from you and maybe your spouse know what there is and who to contact, because if God forbid, something happens to both of you, somebody else can take charge. If you're planning, life plan, if you're having life plan meetings and your child has the capability of participating in these meetings, involve them. It's important to hear what they have to say, especially if it's a young adult or a teen that, has a little bit more understanding and knows what they would prefer and can communicate that to you. Involve them. Now, I mentioned a letter of intent. And what is a letter of intent? This is a non-legally binding document consisting of your intentions for your child. Again, whether it's a typical child or a child that has special needs or specific disabilities. It communicates what your desires are for this child, right? Almost as a guidepost for the future. It can be in audio form, it can be written, it can be a video. In any sort of format that you prefer this letter to be in, make sure that it is well thought out, you've revised it and reviewed it regularly, and that other people have this, right? The people that you want to be involved in your child's future. Special needs estate planning. Review the need for a will. Sometimes people say, well, I don't really have any property or anything. I don't need a will. No, a will is pretty important, especially if you have a child with special needs, because you don't want to leave specific assets to that individual. And, that can bring a lot of problems. One of the biggest issues is them not having the ability to get away from not being entitled to government benefits. If they ever inherit specific assets from you, even though you may not even be thinking about that asset, and it's a far, far memory, that asset or the assets can prohibit your child from accessing means-tested government benefits. So something you want to consider as well is a special needs trust. And this allows for your child with special needs to inherit, but their government benefits that are means tested not to be jeopardized, right? A lot of times previously families thought, well, I have a child with special needs. I should not, leave any inheritance to that child, and their sibling will take care of them. That's not the case. There's mechanisms to allowing that child not be left out and allowing them to still inherit from your estate. Think about who's going to be the executor, the trustee. The trustee is the individual that manages the trust. Who's going to be the guardian or guardians of your minor children? Make sure that everyone over 18 or older has advanced directives or a guardianship in place. Again, I cannot emphasize the importance of that. Be sure that your child always has an advocate, an individual, usually a parent or a sibling. My colleague Allison Morris, who usually does these presentations, advocates for her younger brother, as well as her parents, right? It's a team that knows the individual's needs and advocates for that individual. Review evaluations, review IEPs, support plans, medical plans, medical information. Make sure that everyone's aware that's going to be advocating for your child of their needs and their current statuses. Make sure that the advocates have copies of any life planning documents, right? So if you have a letter of intent drafted, you've given it to the guardian, you've given it to a potential advocate, you've given it to your attorney to keep in your file. Make sure everyone has it so that everyone's aware. And in case something happens, somebody that you trust will be able to guide those other individuals to make decisions and assist your child. So there's a question if these plannings apply the same for undocumented families. Can they still do the same process? Yes. It's so important that even, I know immigration is a big hot topic these days. And it's very important. I mean, sometimes you may have to consider estate planning outside of the United States, in your native country. But if you have anything in the United States, or get a will done. If you have no property whatsoever, right, and all your property is in another country, your native country, at least have advanced directives in place. Guardianship, right? We're going to touch on guardianship very briefly. Guardianship, you can apply and petition the court for guardianship of the person and or of the property of the individual, the respondent, like the court refers to the person with disabilities. This is something that, I do presentations about, and the first question that I'm always asked is if an undocumented or non-citizen can apply for guardianship. The answer is yes, you can. The courts are not required to ask for your legal status in the United States. However, there is no guarantee that the issue may not come about because there is a form, the OCFS form, that requires the 28-year address history. And that's sent to Albany, and that's reviewed before the court proceeds with the proceeding. This is something that, again, it can be done if you're not a citizen of the United States, but there is no guarantee of what may come about and if the immigration status may not, surface. Guardianship, this is different from a legal guardian in your will, right? Guardianship, there's 17As and Article 81 guardianships, and these are petitions made to the court after the respondent is an emancipated adult, has reached the age of majority in New York State at the age of 18. They're plenary guardianships. The Article 17A is a plenary guardianship, and this basically allows you to make all life decisions after your child has reached the age of majority and continue to make those decisions. We recommend that families that are considering filing and petitioning the court for guardianship do so after, the age around 16, 17, because it can take some time. And you don't want there to be a gap between, the teen years into adulthood. Some families petition after their child has turned 18. Maybe they're in their 20s or even 30s. It can still be done, but it's not an ideal time to petition for guardianship. Okay. Funding a life care plan, right? Do you have life insurance? Do you want to use life insurance to support the child? Retitling assets, right? How many families have beneficiary designations and life insurance policies, 401ks, pension plans, even bank accounts, right? And you have your spouse as the beneficiary, or your children, or your relative. And then life goes on and you forget about retitling those assets. And then at the end, it can be a problem, especially if it's an asset benefiting an individual with disabilities, right? It's so important to retitle your assets, especially if you get a special needs trust executed. Those assets should be titled to the trust name, right? So that the individual that's going to benefit in the future is not hindered from access to means-tested government benefits. Yes, somebody's asking about supported decision-making. So supported decision-making, this is something that's not legally binding in the state of New York. It's something that's, surfacing, and some courts, even in the state of New York, have denied guardianship petitions because of supported decision-making. In Florida, I know that there have been 2 guardianship matters turned because of supported decision-making, and the respondent at the time having filed for, this guardianship to be terminated. In New York State, again, it's not legally binding, but some courts are denying guardianship petitions because of supported decision-making. Now, supported decision-making is exactly what it sounds like. It's a group of people helping and supporting an individual make decisions. You and I may have a team of confidants, right, that help us make decisions, but it's a little different when you have children with special needs. Some individuals would not benefit from this because some individuals, are severely disabled, can't speak, really just can't make decisions. If you have an individual that has, more of the capacity to make decisions and you can support them, that's fantastic. But again, you may want to look, you're free to go to the supporteddecisionmaking.org website and look at the decisions and the, the requirements for it, but it's not legally binding in the state of New York. Can guardianship be petitioned when the child is younger? That way it can be put in place as soon as the child turns 18. You can petition for guardianship before the child is 18. We've submitted petitions that when the child has been 16, 17. If you have a good argument for the court may grant it. Sometimes they'll put it on the side until, the age is closer to, the individual's closer to 18. You don't want to have it sit at the court for too long. And again, the court system is a little delayed. Now, even more so, right? Guardianship matters were put on hold because of COVID. They are starting to schedule these guardianship matters, but that's something to take into consideration. Also, one thing I forgot to mention is that for Article 17A guardianships, you don't need an attorney to petition the court. You can always complete the documentation required by going online and printing out the forms. You can go to the courthouse. Again, the courthouses are not really letting people come in. You have questions, you can call the court clerks. When we recommend, some families choose to work with attorneys and not even worry about, the service and the filing and all of that, that's fine. The one time I would suggest that you seek legal guidance is if it's a contested guardianship. So if you feel that, issues are going to come about, if it's maybe 2 divorced parents and there's a battle between the guardianship or who's being appointed guardian or co-guardian or whatnot, it's very important to then have legal counsel represent you. Amanda has put in a link for the court's website. There's DIY programs, and that helps you fill out. You can fill out the forms on the website. Can the social workers working in schools help you obtain those forms for guardianship? I'm sure they can. School districts should be, considering post-secondary and transition plans, including guardianships, advanced directives, Social Security income, right? OPWDD. conversations with you. So I'm sure they could help you. And that leads me to the government benefits, right? There's Social Security, Social Security disability, SSDI versus SSI, Medicaid, means-based programs, right? These are all things that you can look into. Self-settled special needs trusts. These are trusts created with the assets of the child. These are also known as first-party trusts and or Medicaid trusts sometimes, because they have a payback provision. And the payback provision basically is that anything left in that trust at the end of the beneficiary's lifetime will be paid back to Medicaid if the individual, the beneficiary, ever uses Medicaid. This must be established by a parent, this type of trust, a parent, a grandparent, guardian, or by court order. There's third-party supplemental needs trusts. These are trusts established by, a parent or a third party to hold assets for the benefit of a child with special needs. It's not the child's assets, it's, money put in, maybe holiday money, gifts, birthday gifts, any sort of outside resource. Again, parents have the obligation to financially support their child until 21, but thereafter, money can be put into this trust for the beneficiary's benefit. There are certain limitations, and again, it all depends on what's being put in. There is no payback provision and no accounting required, because that's something that a first-party trust also requires, annual accounting to be done, because the government, right, Medicaid has an interest, so the government needs to keep an eye on the assets that are in. And when I reference the government, I mean like Medicaid, like the government benefits, not the IRS. Pool trust. Pool trust, it's a trust established with the child's own assets, and it's managed by a non-for-profit organization. There's pros and cons to this trust, like there is for all other trusts, but the assets in a pool trust are all, everyone's money, people that you don't even know, are pooled into this one trust for investment purposes. And if you need to withdraw money from the trust, you have to ask the non-for-profit organization for permission to withdraw money. When the beneficiary passes, whatever was in the pool trust stays in the pool trust. So again, it has its pros and its cons. Sometimes it's beneficial, sometimes it's the only option. Let me see, how about, can you talk about the ABLE Act and how the trust and how that differs from supplemental needs trust? So an ABLE Act, this is, an account that's set up. Again, it has its pros and its cons. Sometimes you just need to establish an ABLE account, and it can be done with a financial institution. It differs from a special needs trust because it, there's no annual account. Again, it depends what type of special needs trust. If it's a first party special needs trust, it won't require annual accountings. But a third party, it may be the case. It's a very, up in the air type of situation. Like I said, sometimes it's your only option. So, it all depends. How about if I do not have my son's guardianship and I need to take a decision about a health condition? What do I do? So if you don't have guardianship of your son, but you need to make health decisions, you can speak, sometimes doctors or medical professionals will speak to you if your child is over the age of 18. Sometimes you may encounter them not wanting to speak to you, and it's not because they just don't want to speak to you. It's right, their own ethical responsibilities and obligations and HIPAA laws. If you want to avoid encountering a situation like that, I would recommend that you either seek a guardianship and or have your son execute advance directives if he has the capacity to do so. Okay, so just to summarize, right? Every child is unique. You have to come up with a plan early on and review it regularly. Consider establishing, your trusted team and them all being aware of what needs to be done. Once the planning is done, you can breathe, but again, remember to always reevaluate. And, it's an ever-changing plan. Nothing is set in stone until you pass. And so you want to make sure that you're handling the individual's needs appropriately. And when they're, as they grow, right? Because needs change and likes change, right? A lot of intent include what your child's favorite food are, but maybe, today they like pizza and next month they hate it, but they love, broccoli. So always, keep an eye, reassess, and make sure you have your estate planning done, right? Because it's so important whether you have a child that's atypical or with special needs. Always consider your estate planning. Okay. Any other questions? If not, I'm just going to wait a few more minutes and then transition to Spanish. Regarding pool trust, is there any way the beneficiary can request access to some of the funds in the account? Yes, you can always request. No, not the beneficiary. The beneficiary can never have direct access to these funds. No. Okay, so I will be transitioning to Spanish now. Thank you for everyone who participated in the English presentation. Okay, ahora voy a comenzar la presentación en español. Mi nombre es Katherine Aquino-Melendez, soy abogada en la oficina Cuddy Law Firm y yo trabajo bastante con las familias que están planificando para el futuro, incluyendo las tutelas, las peticiones en la corte para los trusts. Algunas cuantas preguntas que debemos considerar son las siguientes. ¿Quién va a cuidar a mi hijo después que yo no esté presente? ¿Dónde vivirá mi hijo, mi hija? ¿Quién será responsable para las decisiones médicas? ¿Quién va a manejar el cuidado de mi hijo, de mi hija? Tomar decisiones sobre la educación. Va a haber suficientes fondos de dinero, ¿verdad? Para asegurar que mi hijo, mi hija tenga lo que necesite e igual pueda seguir viviendo la vida que está acostumbrada. Todo eso concluye con la planificación de vida. Hay que planear y planificar para el futuro, siempre, ¿verdad? Pero especialmente en la situación que estamos viviendo hoy día, la pandemia global que estamos viendo. Es muy importante tener un plan de vida, reconocer las necesidades del niño, de la niña, desarrollar este plan con la familia, si el niño o la niña tiene la capacidad de participar y desarrollar también con los padres e igual la familia, deben de incluir el niño o la niña. Porque es muy importante que ellos se sientan útil y también como parte del plan de ellos, ¿verdad? Porque para el futuro de ellos. ¿Qué se debe considerar cuando se está planificando? Es la condición médica, el cuidado médico, el comportamiento, lo social, lo emocional, la educación y puntos de intereses de vocación. También las finanzas, ¿verdad? Y que haya montos apropiados para el cuidado y el apoyo en el futuro. Otras consideraciones son si el niño tiene la capacidad de trabajar en el futuro, de mantenerse él o ella mismo, ¿verdad? Pensamos que tal vez se casarán en el futuro, tendrán alguna pareja, una familia. No podemos contar simplemente en los beneficios y en el apoyo que el gobierno provee hoy día, porque no sabemos si esos beneficios estarán presentes en 10 años, en 15 años, ¿verdad? Tenemos que planificar para el futuro y considerar todas las opciones que existen. Algunas acciones que deben pensar y considerar son el plan de la vida.
No.
Desarrollar un plan con un grupo de profesionales, ¿verdad? Que puedan asistir, siendo el abogado, el contable, la maestra del estudiante, alguien que pueda abogar por el estudiante o el niño, ¿verdad? También repasar y desarrollar su propio plan del futuro, su propio plan, incluyendo un testamento, los advanced directives, que incluyen el poder de abogado, el poder de decisiones médicas. Son documentos muy importantes que se los recomiendo a todos. Si ustedes tienen algún hijo o hija que tenga la edad de mayoría y capacidad para firmar los poderes, deben de buscar ayuda con un abogado para que lo asistan, porque estos documentos son muy importantes. A ver, regresando entonces al plan de vida. Una carta de intención, ¿verdad? Es lo que usted tiene planificado para la vida de su hijo. Puede ser un hijo con necesidades o de discapacidades, como puede ser un niño o una niña regular. Simplemente para que el que tenga que cuidar de ella o de él sepa a lo que ellos están acostumbrados, cómo usted quisiera que ellos siguieran viviendo su vida. Repasen su plan regular, ¿verdad? Cada año, cada 10 años, repásenlo. Las cosas cambian. Hoy día pueden asignar como un guardián a su primo y en un año usted se da cuenta que su hijo tiene más contacto y una relación mejor con el tío. Entonces asignen tal vez el tío como el tutor del niño. Tengan reuniones. Las reuniones son importantes porque ayudan a que todo el mundo sepa y tenga el mismo plan, ¿verdad? Y tengan las mismas nociones de lo que ustedes quieren. Involucren al niño o a la niña también en la planificación y en las reuniones. Veo que una pregunta: ¿se puede pedir la tutela cuando la persona es inmigrante? Si la persona no es ciudadano de los Estados Unidos, pueden pedir y peticionar a la corte para la tutela ya después que su hijo o hija tenga la edad de mayoría, aunque que recomendamos que se pida la tutela, se someta a la petición unos meses o tal vez un año antes que su hijo cumpla los 18 para evitar el tiempo que se agote ya y que sean adultos. Aún diciéndole que sí pueden peticionar, la Corte no deben de hacer la pregunta de su estatus inmigratorio, pero no hay garantía que el estatus inmigratorio no salga a la luz cuando ustedes sometan la petición. ¿Por qué? Porque hay un documento en la petición para la tutela que pide las direcciones regresando 28 años atrás. Este documento se manda a la capital del estado, a Albany, y se repasa todo. De nuevo, no hay ninguna garantía que salga a la luz lo de la inmigración o si está en un proceso de inmigración. No se lo puedo garantizar, pero eso no lo debe prohibir o prevenir que someta una petición a la tutela. Entonces, la carta de intención, regresando a la carta de intención, no es un documento legal, pero es un documento que provee un guía a la persona que va a cuidar de sus hijos. Como le mencioné anterior, es como un guía para el futuro, ¿verdad? Por si el día de mañana ustedes no están presentes, cómo ustedes quisieran que su hijo o hija siga viviendo, los gustos que tienen, si ustedes lo que prefieren, ¿verdad? Si usted quiere que tengan una crianza específica, una religión específica que sigan, etcétera, ¿verdad? El plan del futuro para el niño o la niña. Y repasarlo regularmente. Planificar para el futuro. Esto no solamente incluye el testamento, ¿verdad? Porque a veces las familias, los clientes me dicen, bueno, yo no tengo ninguna propiedad, yo no necesito un testamento. No es siempre cierto. Un testamento es muy importante, especialmente si uno tiene un hijo o una hija con necesidades especiales. ¿Por qué? Porque antes la gente pensaba que tenían que desheredar al hijo o la hija que no tenía la capacidad y tenía alguna discapacidad y que, por ejemplo, el hermano o la hermana de ese individuo lo iba a cuidar. No, esa no es la realidad. Hoy día hay modos de poder incluir a ese hijo o hija y no desheredarlo con un Special Needs Trust, un trust de necesidades especiales. También, como mencioné al principio, los Advanced Directives son muy importantes. ¿Le puedo pedir que tengan el volumen en mute, por favor, el micrófono en mute? Gracias. Asegúrense de que ustedes aboguen y que haya alguien que pueda abogar por su hijo o su hija. Puede ser otro padre, un hermano, un pariente, las personas que sepan o que usted le puede explicar las necesidades y conozcan al niño o la niña, ¿verdad? Mi colega Alison Morris, que hace estas presentaciones semanal, ella, igual sus padres, abogan por su hermano menor. Saben las necesidades, saben lo que le gusta, entonces es muy importante que ustedes tengan ese plan y sepan con quién pueden contar. Es importante que si tienen un plan del futuro o por lo menos una carta de intención, que los que vayan a abogar por su hijo o hija tengan copias. También si ustedes tienen un abogado de familia, un contable, alguien que ustedes confíen, que le den copias de estos documentos para que ellos también sepan, por si, por ejemplo, lo único que tienen copias es usted y su pareja y algo le ocurre a los dos, entonces alguien está disponible para proveer la información. Las tutelas de la persona y de la propiedad. Se puede peticionar a la Corte para una tutela del 17A, eso es específico para el Estado de Nueva York, y permite que ustedes tomen decisiones de su hijo o de su hija después de que cumplan la edad de mayoría. De nuevo, de la persona y o de la propiedad. Esto se hace peticionando a la Corte, no necesitan abogados, pero sí les recomendamos que busquen un abogado, la asistencia de un abogado, si va a ser una tutela que pueda tener problemas. Si son una pareja que están divorciados o no están de acuerdo con quién va a ser el tutor o el tutor alternativo, es importante que busquen la ayuda de un abogado. Si no están buscando la ayuda de un abogado porque una tutela simple, pueden bajar los documentos o llenarlo a través de la página de internet. Si suben el chat hacia arriba, Amanda incluyó la información a la página de la corte. Pueden llamar a la corte donde ustedes residan en el condado o pueden ir. Hoy día es un poco difícil ir a la corte. Las cortes no están permitiendo que la gente entre, si no es que tienen un caso vigente, pero los secretarios en la corte pueden ayudarlo a llenar los formularios y son bastante agradables. Estoy leyendo una pregunta, disculpe por en el tema, pero yo soy inmigrante y fui a un taller de Guardianship y la persona que dio el taller me dijo que si era necesario ser residente o ciudadano para pedir la tutela. Si la persona le comunicó eso, está bien, pero yo he preguntado en la corte, yo someto bastante peticiones a la corte y he trabajado con clientes que no son ciudadanos, pero de nuevo, siempre se le advierte el riesgo que existe. Los formularios están disponibles en otros idiomas y en la computadora. Y también si van a la corte, las secretarias en la corte o los secretarios pueden ayudarle. A veces hay personas que hablan español o otros idiomas. Si tienen seguro de vida, si tienen pensiones, cuentas bancarias, es muy importante que si creen un testamento con un Special Needs Trust, un trust para necesidades especiales, ¿verdad? Para que su hijo o hija con necesidades no sea desheredado. Es importante que cambien el nombre de los beneficiarios en esos documentos, ¿verdad? Por ejemplo, si en su seguro de vida ustedes tienen a su pareja y a sus hijos, uno de los cuales tenga necesidades especiales, es importante que ese individuo, ya claro, después que hayan creado un trust para ese individuo, cambien el nombre de ese individuo al nombre del trust, porque si no, ese individuo, cuando ustedes mueran, van a ser beneficiarios de ese seguro de vida y puede afectar los beneficios que reciban del gobierno. Okay. Servicios de gobierno, Social Security, Disability, Medicare, Medicaid, Supplemental Security Income, ¿verdad? El Social Security, varios programas. Hablar entonces sobre los trusts y cómo proteger que los beneficios del gobierno no sean afectados. Uno es el Self-Settled Special Needs Trust o el Trust de primera persona creado con los beneficios y dinero del individuo, del niño. Esto incluye lo que se llama una provisión payback, lo cual Medicaid, cuando la persona, el beneficiario del trust muera, Medicaid se le puede mandar una cuenta y pedir que si ese individuo usó Medicaid durante su vida, cuando el trust existía, que le paguen lo que reste en el trust, si resta algo, claro. También hay que someter una contabilidad anual a la corte y a Medicaid. El individuo nunca tiene acceso directamente a los montos en ese trust. También existe el Third Party Trust, o un trust creado por una tercera parte, y esto es igual como suena. Un trust creado con dinero de una tercera parte, un pariente, un abuelo, un primo, lo que sea. No tiene el payback provision y no tiene que someter una contabilidad anual. De nuevo, la persona no tiene, el beneficiario del trust no tiene acceso al dinero directamente. Si la persona haciendo la petición de tutela tiene ya la custodia total del niño, estipulado por la corte, el otro padre puede aún pelear a la tutela. Puede que sea, porque la tutela de la corte es cuando sea un menor, pero ya después que sea un adulto, las cosas pueden cambiar y tal vez el padre quiere ser parte o tal vez usted quiere, o sea, la persona quiere involucrarse ahora en la vida del adulto. También existe un pool trust. Este es un trust que todo el dinero del individuo va hacia una piscina, ¿verdad? Un trust piscina, lo que se traduce. Y es manejado por una organización not for profit, que no requiere ser pagado, pero el problema es el con de este tipo de trust es que si cuando el beneficiario muera, lo que haya de ese beneficiario en la piscina no se puede tocar, porque ese dinero es reinvertido a través de la organización continuamente. También es manejado por esta organización, entonces si el trustee quiere pedirle dinero a la organización para el beneficio del individuo, tiene que solicitárselo a la organización. ¿Verdad? Entonces, para concluir, vamos a repasar. Lo importante es que cada niño es individual, es único, tiene sus necesidades, ¿verdad? Diferente al del hermano o la hermana. Es importante planificar para el bienestar de cada niño, siendo un niño sin discapacidades o uno con discapacidades. Planificar para usted mismo, ¿verdad? Para asegurarse que usted tenga todo lo suyo coordinado para un plan del futuro para usted, su familia, incluyendo sus hijos. Busca ver un equipo especial para el niño con discapacidades, alguien que usted confíe, tal vez el terapista del habla, un psicólogo en la escuela que tiene buena relación, sus abogados, sus contables, ¿verdad? Alguien que abogue por su hijo. Téngase un equipo que usted confíe y pueda ayudarlo a desarrollar planes. Y estos planes, ¿verdad? Seguir repasándolo, cambiándolo si es necesario. Todo evalúa y reevaluar todos los años, tal vez cada 5 años, lo que usted determine. Pero es importante que ustedes estén repasando todo esto y todo va cambiando, ¿verdad? Entonces es importante que los planes suyos cambien igual. Voy a esperar unos minuticos más. Me quedan 5 minutos a ver si alguien tiene alguna pregunta. If an adult child has accrued loans for whatever reason before guardianship is established with the guardian, be responsible to the loans of the adult child before guardianship was. There's a question regarding accrued loans. This is a very case specific, and again, it depends what type of loans and or guardianship exists. So I really can't provide a specific answer. I'm sorry. Podría hablar un poco más de la devolución de fondos en uno de los trusts. Pienso que habla sobre el first party trust para devolvérselo a Medicaid. Esto es simplemente un trust, first party trust, cuando es creado con los fondos del individuo, ¿verdad? De la persona que va a ser beneficiario del trust. Por ejemplo, un niño tiene hay una demanda y resulta que el niño se beneficia de la demanda monetariamente. Ese niño tiene que entonces crear, o los padres crear un trust. Si ese individuo usa Medicaid durante la vida, en cualquier momento que ese trust esté en existencia, Medicaid al final de la vida de ese individuo, cuando el niño o la niña muera, ¿verdad? O el trust ya no tenga que existir, porque tablas de capacidad no existen ya, entonces Medicaid puede solicitar que ser pagado por los servicios que le proveyó. Obviamente, si hay $10 en el trust y Medicaid está pidiendo una suma de $5,000, no van a pedirle a los padres ni a alguien fuera que le pague la suma, la diferencia. Ellos pueden determinar, bueno, quedan $10, eso no me va a servir para nada, o denme los $10, ¿verdad? Si tienes propiedades fuera de los Estados Unidos, se deben incluir. Propiedades fuera de los Estados Unidos, el testamento no puede incluir esas propiedades. Lo que les recomiendo es que hable con un abogado en el país donde tengan las propiedades, porque las leyes son diferentes en cada país. Y esas propiedades, de nuevo, no fueran incluidas en el testamento de los Estados Unidos. Pero sí, si vive en los Estados Unidos, aunque que no tenga propiedades, vive en los Estados Unidos, entonces les recomendaría los Advanced Directives para que firme un poder de abogados, un poder de salud, etc. Again, student loans, it depends what type of guardianship, and if the individual had student loans, is a guardianship even appropriate? You know, it's a very case-specific question again. ¿Alguna otra pregunta? Any other questions? Si tienen alguna pregunta o quieren hacer iniciar algo, pueden llamar a la oficina principal de Cuddy Law Firm, y si no, nos vemos la próxima semana. Thank you very much for everyone who participated. Puede hacer la tutela después de los 18, sí la puede hacer, pero no lo recomendaría. Recomiendo que se haga antes que el individuo cumpla los 18. Si no tiene familiar y cercano, puede ser un amigo. Para la tutela, pienso que me está preguntando, Sí, puede ser un familiar, un pariente, un amigo, un vecino, el que usted tenga confianza. ¿Pueden poner la información de la oficina del abogado, por favor? Amanda va a incluir la información de la oficina. Amanda, can you include the office information, the contact information? We will add you, Rocio. We will add you. Again, thank you so much to everyone who participated. Gracias a todo el mundo que participó. We will see you next week. Los vemos la próxima semana.